all property acquired during the marriage, no matter who earned it, no matter who made it happen, is marital property. All property that either party had prior to the divorce or either party received through gift or inheritance from a third party that they have not commingled with marital property is separate property. The court can only divide marital property. Marital property can be all sorts of things, from real estate to automobiles to furniture to bank accounts to retirement accounts, anything that is something of value. The court divides this property based on equity. What's fair and reasonable on the circumstances? If the husband rides a motorcycle, more than likely he's going to get his motorcycle. That's fair and reasonable under the circumstances. If the wife has a car and the husband has a car, probably they're going to each get their own individual automobile. Usually they're going to get the one that they've been driving historically. But sometimes, no. Maybe the wife was driving the clunker and the husband had the nice vehicle, and now the wife's getting custody of the children. Well, the court may decide that the wife needs the better vehicle in order to make sure the children are transported in a safe manner. That's equity. It does not mean equal, but usually it comes out that way. Assume the judge is going to try to divide the assets equally between you unless you give the judge a reason not to do so. Now, when I say dividing them equally, that doesn't mean everything's going to be cut in half, each item. No, it means that the values are going to be established for all the property, for each item of property. And then hopefully when you add up the property that the husband's getting and you add up the property that the wife is getting, the bottom line value is equal. So perhaps the wife gets the house and the husband gets the retirement accounts. There's all kinds of ways to balance these things. And that's why you need a good attorney in order to present the facts and make a proposal to the judge. Remember, a judge is only going to hear a few hours or a few days of testimony. They want your lawyer to give them proposals, to give them solutions so that they then have something to work from. They may not take either lawyer's proposal, but it gives them a starting point so that they can then start looking at it and say, well, I like this idea, but I don't like that idea, and come up with what they think is equitable. In divorce, you have marital property and you have separate property. Separate property is all property that was acquired by either party prior to the marriage. It is also all property received through gift or inheritance from a third party during the marriage or prior to the marriage. Suppose the wife's parent dies and leaves an inheritance. That is the wife's separate property. However, it can lose its separate property designation if it is commingled or titled in the other party's name or in joint names. So it's important for an attorney to evaluate the facts to present to the court what is separate and what is marital. An example of commingling of separate and marital property is a home. If, say, one party owns a home prior to the marriage, but there's a mortgage on that home, well, then they make payments on that mortgage during the marriage. Well, that home now has a separate property aspect and a marital property aspect because marital funds were used to make payments on that home. So you use the case of Thomas v. Thomas, which is a complicated calculation in which you evaluate the contributions to that home from separate assets and the contributions to that home from marital assets in order to present your case to the court of what you believe is the separate property aspect of the home and the marital property aspect of the home. Then the court can only divide what it determines to be the marital aspect of that home. Dividing retirement accounts and the pensions in a divorce can be very complicated. Quite often during a marriage, one spouse may have the ability to establish retirement accounts or pensions, and the other party does not. Maybe someone's a stay-at-home parent, doesn't work. Well, they certainly have relied upon the promise from their spouse that those pensions and retirement accounts are going to be available for them in their old age. And so they have an equitable claim on those things. Most retirement accounts can be divided through a tool called a qualified domestic relations order. This is a special order that is entered by the court and that instructs the representatives of that pension or retirement account on how they should divide that pension. There are very special rules in regard to this. There are federal regulations in regard to this. Some pensions, some retirement accounts cannot be divided. Usually school teachers' retirement accounts are not, in Georgia, are not subject to division. So a court has to look at the value of those things and try to offset them with some of their asset. And it's important that you have an attorney that understands the nuances of these retirement accounts, what can and cannot be divided. Military retirements, they can be divided, but there's a whole another set of rules in regard to that. You have to prepare these documents for a quadro and submit them to what's called a plan administrator, and it has to meet the rules of the plan. So the attorney prepares the document, sends it to the plan administrator. The plan administrator takes a little time, looks at it, and writes back and says, well, this meets our rules and we will accept it. Or they may write back and say, well, this doesn't meet our rules, we can't accept it. I actually had a case one time with a Teamsters union, and I sent it a quadro to them, and they sent me a list of things to change. I made those changes and sent it to them. They sent me a list back again with more changes. After the 5th attempt, we finally got it approved. They kept changing the rules. You have to satisfy the plan administrator. You have to satisfy the court. It's very complicated. Sometimes it's guesswork because each plan and plan administrator interprets the law differently. So it's important that you have an attorney that's willing to work with these people, negotiate these things, and get these retirement accounts divided properly so that each party has the retirement that they're entitled to. A marital home is split in Georgia under the principle of equitable division of property. What's fair and reasonable under the circumstances? Quite often, the parties are ordered to sell a home, especially if you cannot come up with a budget that shows that one or the other of them can afford the home after a divorce. You got to have the money to pay the mortgage. And often the court will order the parties or one party to sell that home. It doesn't matter whose name the house is in. If it was bought during the marriage, it is marital property. If it has a marital aspect to it because there's been mortgage payments made on it from marital funds, it is marital property. The name on the house is irrelevant. That's easily changed by court order. So sometimes we see houses being sold. Sometimes the court awards the house to the custodial parent because they see that they can afford the home, and the court wants to keep the children in the marital home so that their life is changed as little as possible after the divorce. Sometimes it's a home that maybe was a family home. Maybe it was a husband or the wife's parents' home previously and they bought it from them. So there's an emotional tie. All these are factors to be considered. I have had cases where one of the party's parents actually owned a 50% interest in the home and the couple owned the other 50% interest. That's a factor to be considered. Uh, all these things have to be considered, the evidence gathered and presented to the court, so that the court can make a fair and reasonable decision on how a home is divided. If you have any question about how houses or assets are divided in the state of Georgia, call Daniels and Taylor. We're here to help you.